here's what the judge said. First of all, according to the defendant in this case, her son was home with the alleged victim about 3 months before this incident happened, and he was assaulted by the victim in the case. Allegedly, the hearsay, the judge says, I'm going to reserve ruling on that particular incident. Then the defense says there was another incident about 7 months before this incident occurred, in which again there was an altercation between the victim, DeMonte, and the defendant's son. And when that happened, there was a police report. Defense argues that goes as to her intent, her knowledge of the propensity of violence by the victim in the case towards the defendant's son, and the judge ruled that can come in. I am so grateful to have an expert here on set with me, my guest for this hour in studio, trial attorney Ted Spaulding. That's a lot, Ted, that I just blurped out, but I wanted everybody to understand where we are. What is your initial reaction to the judge's decision and what gets to come in?
Yeah, I'm actually somewhat shocked that it comes in. It's a slippery slope, and once you bring in one, why not the other? So if we have one 7 months before, we have one 3 months before. If the 3 months is reserved, but we're bringing in the one 7 months ago, I don't quite understand it, because in my experience, first we got to have testimony. Where's the testimony that this is what created her fear? In these self-defense cases, it's very hard for the defense, as you know. They've got to show that she had a reasonable fear. And so if they're going down the road of, listen, she had a reasonable fear that he was going to do this at this moment to the 12-year-old, that's a different story. But my understanding is this is kind of a more broad intent argument. And I'm not quite buying that, in my opinion. I'm shocked it's being let in.
And I guess where's the reasonable fear based on something that happened 7 months ago? Now, the one difference I see between the incident 3 months ago with the defendant's son versus 7 months ago with the defendant's son is the one 7 months ago, there's a police report. But you and I both kind of said the same thing, which is the defense just said to the judge, we don't have that. The state has the police report, the defense doesn't. It just makes me feel like there's a little bit of scrambling by the defense to figure out, okay, if we can't get it in that way, let's get it in this way. But theoretically, should the defense not have had a copy of that police report?
Yeah, and I would go a step further. 911 recording. These are very easy things to get. We have it oftentimes in the civil side. GORA requests, Georgia Open Records Act request. You can have it in 3 days. Assuming it's still available, it hasn't been destroyed. Where's the tape? Because if we're getting into this argument about her intent and all that, if she was the one that called 911, for instance, shouldn't we hear what she sounds like when she's calling? Do we hear the fear? Does she make any statements that he might do this again? Or, you know, any of those sorts of things that could help the defense say, see, Judge, hear what she says here. I was shocked as we were listening, doesn't even have the police report. Yeah. But I'm saying, show the police report, show the 911, listen to the 911 tape, Judge. You know this is such a critical moment in your defense of a self-defense case. I would have all of that.
Yeah, it is interesting, and I almost feel like it's, oh, the 3 minute isn't going to be, the 3 month incident before isn't going to be allowed, but the 7 is, oops, we don't have that. I don't know. I think that how this shakes out is really going to depend, Ted, on the testimony of the defendant, and you all don't want to miss this because that's up next, and I stand by, in my opinion, this case hinges on the credibility of the defendant while she's telling her story. You don't want to miss it. Her testimony right on the other side of this break. You're watching Court TV, your front row seat to justice.